weekday to talk about trademark law and other interesting stuff. If you like this video, please share it with others if you think they might value it. So yesterday I talked about the fact that Procter & Gamble was registering or had applied to register the term LOL for some cleaning products. Now, this prompted a number of questions, as you can rather imagine, and I want to address those today. So one of my viewers asked, my local newspaper has been using LOL for probably 2 decades, and Procter & Gamble is not going to be able to get away with that because LOL is in common use in language around the world. Well, his question, or rather his statement, assumes 2 myths about trademark law. One of them is that if a mark is already registered, then it is necessarily unavailable for any subsequent registrants. That is not true. The second thing that it assumes is that if a word is in common usage, it cannot be used as a trademark. I'm going to address those 2 things in turn. Now, as to the first issue, if a mark is registered, can subsequent registrants come in and register it? And the answer to that is absolutely yes. This is why we have, for example, United Airlines, United Van Lines, and United Parcel Service. Why can these marks coexist in the marketplace with the common word United in them? Well, it's because consumers don't expect those types of goods, airline services, household moving services, and parcel delivery services to, as we say in trademark law, emanate from the same company. In other words, it's not at all common in the marketplace for one company to provide all 3 of those services. Therefore, when confronted with the United mark for those separate services, the consumer is not going to be confused and believe that the same company is providing all 3 services. Why? Because it's not usual in the marketplace for that to be the case. So we look at the consumer experience in the marketplace when we're deciding if consumers are going to be confused. That's one factor. Now, as to the second issue, as to the LOL is in common usage, so we can't use it as a registered trademark. Well, that's wrong as well. I can come up with many examples of common words that are being used as trademarks. Jaguar for cars, Apple for computers and electronic goods, Bell for telephones and other electronic goods, Android for, cell phones, Galaxy, same thing for cell phones. So why can these terms be used as trademarks? Well, recall that trademarks have to be distinctive. They can't be generic, and they shouldn't be descriptive. So we are going to refuse a registration for a generic mark. A generic mark is one that is actually the name for the goods being sold. So, for example, if I sell apples for a living, I've got Angela's apple cart, I cannot register a trademark for Apple for my apple cart because the term apple describes the goods that I am selling, and therefore it is not distinctive. In addition, if the trademark office were to allow me to have the exclusive use to use the word apple on my apple cart, it would prevent other people from fairly describing their goods. They wouldn't be able to say, hey, I sell apples too. But we can, in contrast, use the word Apple for a trademark. It's a very famous trademark for tablet computers and mobile PCs and phones and a whole host of other electronic devices. So as long as the mark that is a common word is also not describing the goods or the purpose to which the goods are put, you can use a common word as a trademark. So I hope that clears up the confusion. As always, I welcome your questions, and you can feel free to message me at my Facebook page at Trademark Doctor to ask me more questions. And you can find me online at TrademarkDoctor.net. If you like this video, please share it with others. They might find it useful too.